Welcome, and thank you for joining us for our Zoom conference on truth in sentencing in Michigan. Everyone at Safe and Just Michigan is thrilled you are participating. We've muted your microphones to ensure that everyone can hear the panel, but please ask any questions you have using the chat function on Zoom. You'll find the chat function on the taskbar when you hover your mouse over the bottom of the screen. For anyone who has not used Zoom before, the chat button is the one that looks like a talk balloon. At the end of the panel, we will gather up and answer questions for as long as time allows. We'll be putting links to an exit survey and to ways to get in contact with us at Safe and Just Michigan on the screen at the end of the panel discussion. You'll also be able to find those links during the event in the chat room. For those of you who want to revisit this discussion, we are streaming this event on the Safe and Just Michigan Facebook page through Facebook Live, and we put up on the Safe and Just Michigan YouTube channel later this week. You can also engage with us on our social media or using our website. John?
Thanks, Josh, and thanks everyone for joining. We think truth in sentencing is a very important subject and a very timely one as well amidst the COVID crisis. As you guys probably know, there's a large outbreak of COVID in Michigan's prison system. Last I checked, there were 38 deaths and over 1,300 cases that have been confirmed. We're hearing from people who are incarcerated that there's likely quite a few more than that. The testing has been limited. Truth in sentencing has impacted many aspects of the Department of Corrections' response to COVID, from the people they're considering for release proactively to how they care for people who are sick, and also to how they're segregating people who are not sick from sick people. Our truth in sentencing law says that a person must serve 100% of their minimum sentence in a quote unquote secure facility. And that simple requirement has profound consequences for MDOC's authority to manage the people in its care. And also it has huge consequences on how long people serve in prison in Michigan. So I'm joined today by three experts on truth in sentencing. First is Dr. Ayn Mahar. It's Safe and Just Michigan's dedicated researcher. She has a bachelor's and a master's in criminal justice from Eastern Michigan and a PhD in criminology and criminal justice from Old Dominion University in Virginia. Next, we have Imani Suwari. She's a writer. She's founder of the site suwarimi.org and coordinator of the Good Time campaign to repeal truth in sentencing through a ballot initiative. She's a 2019 Civil Rights Fellow with the Roddenberry Foundation and graduated from the University of Washington with her bachelor's degree in media communication studies and law, economics, and public policy in 2016. She is, I believe, a Michigan native, though, and is back in the state to advocate. Finally, we have Jessica Zimbelman from the State Appellate Defender's Office. She's an assistant defender at SADO, representing indigent criminal defendants statewide as they appeal their convictions and sentences. Prior to SADO, she was senior analyst in the Legislative Corrections Ombudsman's Office, monitoring MDOC on behalf of the legislature. So I want to start big picture. And the question is, what is truth in sentencing? And I want to start with Jessica. Jessica, can you tell me what, from a legal matter, what does truth in sentencing require?
Truth in sentencing, hi everyone, and thanks for joining us to talk about this important topic via Zoom, our new favorite place to congregate these days. So truth in sentencing, putting it bluntly or simply, I guess, is that a series of statutes that was enacted effective in 1999 that requires all people who are convicted and serving a prison sentence that they have to serve every single day of their minimum sentence. And that wasn't the case before. There's a whole slew of and I think Anne's going to talk about this a little bit, but there was a whole different regime based on when your conviction was, whether you got disciplinary credits, good time, all these different things to incentivize good behavior to reduce that minimum sentence. So now, though, if you were convicted in 1999 or after, you have to serve every day of your minimum sentence. And we're going to get into the nitty gritty nuances of that and the problems with that and the problems that I see every day representing people who are appealing sentences that are too long to begin with, let alone the fact that they're often held beyond that earliest release date as a result of parole board functioning and different administrative things. So that's kind of what it means. You have to serve every day of your minimum sentence.
And the statutes also have a particular constraint on where that sentence can be served, right? It says in a secure facility. Do you have a sense of the legal requirements for what a secure facility is?
I don't have a sense of that, but I do know that, and Anne looks like she does. So I'm going to kick it over to Anne to answer that question.
Great. Well, maybe I could ask a few questions to draw it out. So Anne, is a hospital a secure facility?
No, a hospital is not a secure facility. Neither is a halfway house, house arrest, or any of those things. In order for it to be considered a secure facility, the facility has to be enclosed by a lock fence or wall designed to prevent people from leaving the enclosed premises, that is patrolled by correctional officers. They are restricted to the area inside of the wall or fence, and those who are there must be under guard by a correctional officer 24/7. So there are no facilities that meet those requirements that are not a prison.
So I want to go to Imani next. Imani, we're in the middle of a pandemic, but MDOC can't send sick people in their care to a hospital. What has MDOC been doing with sick people during the COVID pandemic?
During the COVID pandemic, we've really seen how Truth in Sentencing has highlighted the critical situation that we have in our sentencing structure. So what's been happening with sick people that have been diagnosed with COVID, they've been making makeshift quarantine areas. And some of those areas have been visiting rooms, the lobby areas that used to be used for people to wait to go into the visiting room. Now that visits are no longer allowed, families can't come in and visit their loved ones, those spaces are being repurposed to house people who have been diagnosed with COVID-19.
And what has been done with people who don't have COVID, but could get it? For example, medically vulnerable people, aging people, those folks haven't been sent outside secure facilities either, right?
Exactly. So a lot of people who were already battling illnesses like diabetes or heart disease or just elderly, people who are asthmatic, people who fit under those vulnerable at-risk populations have just been mixed within general population. They're not getting the care, the individualized care and treatment that they would have been getting prior to the COVID crisis. So people who already needed medical care, who already needed specialized attention are now falling to the wayside, and they're not getting the treatment that they would have gotten otherwise. They would get treatment and moved into a COVID quarantine area if they happen to get COVID. So now, because so much of the focus has been on quarantining individuals and separating people based upon whether they have COVID, whether they've been diagnosed, whether they've been tested, whether they're in a step-down facility, so if they've already been diagnosed and it's been 2 weeks, that's been taking up a majority of the focus rather than the individualized treatment that people should be receiving while they're in prison.
And I want to go back to Jessica. So do you have a sense, Jessica, of roughly what percentage of the prison population in Michigan is eligible for parole at this point in time?
I believe, I think it's like 15%. You probably actually have the numbers way better than I do. But I think it's 15%. Yeah. So I can talk about some other percentages of appeals and whatnot, but I think it's relatively high when you look at the number of people we have incarcerated. You're looking at the thousands of people that could potentially be released right now.
Right. So MDOC only has authority to release people that are in that 15%, right?
Correct. So how it works, this all goes back to the minimum sentence. So in Michigan, it's a very, and I'll just kind of talk a little bit about sentencing because that's where this comes into play in the first place. In Michigan, your minimum sentence is based on 27 different factors and the judge's whims for the most part. There's the statutory sentencing guidelines, which are very complex. They're very easy to make mistakes in. And looking at, there's 20 factors about the offense, there's 7 factors about a person's prior record, and the judge then calculates those with the assistance of MDOC probation, and that comes up with a range. And so the judge can sentence somebody anywhere in that range of months on the minimum sentence. The judge, of course, then has the discretion to depart from that guideline range, either up or down, with very little appellate recourse for a departure from the guidelines. But what that means, and why I brought up the percentage of appeals, is that only the last numbers we have available for people taking appeals is 2018. And in those appeals, only 40% of people who were convicted by trial appeals their conviction and sentence. And only 5% of people convicted by plea appeal their conviction and sentence. And a vast majority of people are convicted by plea in the state and in the country, somewhere around 95%. So only a very small fraction of people actually appeal. And as an attorney at the State Appellate Defender Office, where we see a wide variety of appeals from across the state, we are constantly finding sentencing errors. So when you have such a low number of people appealing their convictions and sentences, that's another thing that drives our prison population, is because you have people potentially serving longer sentences, minimum sentences that they need to, and then they have to serve every day of that. So, that minimum sentence really controls, and then once they reach that, everything goes over to the parole board. So there's that wide amount of time between the minimum sentence and the maximum sentence, which is set by statute. So all of that time in there is in the jurisdiction of the parole board. So they have a lot of power. And yeah, I can talk more about the parole board when the time is right.
Yeah, so for the other 85% of prisoners, I mean, do they have any recourse whatsoever with MDOC?
Not with MDOC. So you're talking about people who are not eligible for parole yet. Their only recourse is through the governor's clemency and commutation powers.
Right.
That is their recourse. And that is a power that is typically not used very often, and certainly not in the middle of a governor's first term. You typically see these commutations and clemency actions towards the end of when a governor is leaving office. Governor Whitmer, in her last 2 press conferences, has been asked about her clemency power and whether she's going to start using it to help the prison population, as we've seen these numbers skyrocket. And she has so far not indicated any interest in doing so. She has mentioned that even if she were to do that, it would still have to go through the same process with the parole board, which she is, she's right about that. But we can talk about, I think, what she might be able to do to alleviate some of the problems with the process as it exists now.
So Anne, I want to go to you next. Can you tell the group, so Michigan has, I would say, a very punitive sentencing system, and we have some of the longest sentences in the country. What's the average minimum sentence in prison in Michigan?
So you're right, we are pretty punitive. We are one of only 6 states that do not have any time of good time available to those who are incarcerated. And our current average length of sentence, average time served is 4.3 years, which increased almost 80% between 1990 and 2009.
Do you have a sense of how much that increase was due to truth in sentencing? I think I saw somewhere that prior to the 98-99 law, that people were serving 88% of their minimums in Michigan's prisons. What did that increase to after truth in sentencing?
So there have been multiple reports actually crediting Michigan's truth in sentencing law to the entire increase in the length of sentence. Because, right, like as you mentioned, we were at an average of 88% of sentences served. Truth in sentencing put us at 100% of minimum sentences served. And then the Council of State Governments in 2014 found that on average, people are spending actually 125% of their minimum sentence before they are released on parole. So we've seen this huge increase in the length of stay, almost entirely due to policy changes, nothing to do with crime rates or anything like that.
Right. So you mentioned crime rates. We've seen sentence length go up. At the same time, we've seen crime rates go down. Is there any research out there on whether there's a relationship between those two things?
So that I would say the relationship between incarcerated populations and crime rate has a healthy bit of a debate in it, but generally a lot of people are suggesting that our prison increases have actually happened independently of our crime rates. So for example, violent crime peaked in Michigan in 1991. And then, right, we first see truth in sentencing introduced and passed in 94, then actually implemented in 99. So, right, coming up on 10 years after we already had our peak and crime was significantly decreasing. So there isn't really a discernible relationship between how much crime is actually happening and how many people we have incarcerated.
Okay, I want to go to Imani next. Imani, is truth in sentencing a good idea?
That's an easy question. No, and truly because there is no real truth in the way that we sentence people. There's no way that any judge or prosecutor can look at an individual, whether they're 15 or 50, and decide for a fact when that person is going to be fully rehabilitated and ready to come back into society, which is why it's so important for us to have a sentencing structure that allows for people to earn time off based upon factors like academic, behavioral, and professional achievement. Truth in sentencing really is a falsehood, and it takes the truth out of our sentencing structure. So it's very cleverly named by those who advocate for it, but it's definitely not a good policy. It doesn't serve anyone. It doesn't serve people in prison. It creates a overcrowded situation. It limits the amount of resources that we can use to individually serve people, and it keeps families and their loved ones on a string with little to no hope of when they can be reunited.
So just to pick a point you raised, so what a judge is doing at sentencing, that's not a prediction of when a person will be rehabilitated. It's a punishment, right?
Mm-hmm.
Those are two different goals, right?
Those are different goals, yes. The goal of a judge is to put together a punishment that is going to be equal and give some sense of justice back to the community for whatever wrongdoing the individual has done that landed them in court. However, a part of our justice system, what's supposed to be a justice system, is rehabilitation. There is no real justice in what we are doing when we send people to prison if no rehabilitation is happening. There's no sense of restoration if a person hasn't gotten better as a result of the time that they've spent in prison. So although we are trying to punish an individual, a part of that punishment should definitely cause that person to reflect and become a better person. Someone spending a longer time in prison is not equivalent to someone becoming a better person. We see this, we know this. So it's not just punishment. And because Michigan is so focused on punishment and is so over punitive, we really need to go the extra mile in trying to add some restoration to our prisons by finding some rehabilitative ways and programming to implement into our punitive structure.
Jessica, you mentioned the sentencing guidelines earlier. Can you talk about the kinds of factors that the sentencing guidelines take into account when making a sentence recommendation to a judge?
Sure. So again, as I mentioned, it's a very complex system, and it depends what guidelines are scored as far as the offense variables depend on the type of offense somebody's convicted of. But generally speaking, the type of things that are scored when it comes to the offense variables involve whether there was a weapon present, how lethal that weapon is, whether there was psychological injury to a member of the victim's family or to the victim his or herself, whether there was excessive brutality, whether there was any asportation or movement of the victim, the number of victims, whether there was terrorism involved. I mean, we've really gone off the deep end in Michigan as far as scoring different variables. You look at a person's prior. Oh, go ahead.
Well, I was just going to say, are any of those variables attempting to measure a person's likelihood of rehabilitation and how long that would take?
No, we don't. And one thing that is different in Michigan than in the federal system is that we don't have any mitigating offense variables. So that would be something that might actually get to rehabilitation. For example, if a person has employment, if a person accepts responsibility. In the federal system, you get some benefit if you accept responsibility. And since 95% and higher of cases are resolved by plea in Michigan, that could go a long way. So we could get these minimum terms down. And I did notice one of the questions about sentencing in Michigan was about whether the judge had to have really good reasons or substantial and compelling reasons to depart from the guidelines. And that used to be the case. But maybe been 3 or 4 years now, Michigan's guidelines became advisory instead of mandatory. And with that came more power for a judge to depart from the guidelines. So essentially the sentence just has to be reasonable, which is a very hard standard to define and argue against on appeal, but it's also very deferential to judges. So judges do have a lot of power in Michigan to ratchet up those sentences. And of course, I'm only seeing the upward departures when they go above the guidelines. I do know that there are judges out there who will go below the guidelines, and people might not appeal those sentences.
Sure. So I want to go to Annie a minute. So we've been talking about sentence length. What is the research, Annie, on the effectiveness of a long sentence on public safety? Is there, the state pays about $35,000 a year to incarcerate someone for that year. So that's that's an investment in public safety. Is there a good return on that investment in a long sentence? Is there a big difference, for example, in public safety between a 10-year and a 20-year sentence?
No, it's a pretty horrible return on investment. Research has kind of consistently shown that length of sentence, the difference between 5 and 10 years, 10 and 20, does not make a very big difference. It doesn't really do much for public safety. The real focus is incapacitation and that idea of punishing the person who, has been found to do wrong. No, their length of sentence does not make us more safe.
So why do we have truth in sentencing? That this is not good policy. And it's my understanding, Annie, that it wasn't policy in Michigan until fairly recently. Can you talk a little bit about the history of good time and truth in sentencing in Michigan?
Gladly. Good time in Michigan actually starts way back in 1857, 20 years after Michigan actually became a state. So good time credits has been part of Michigan for almost as long as Michigan has been Michigan. Good time credits were further solidified and formalized as Michigan formalized their corrections and prison system. So when we're talking about good time credits were a progressive system that allowed incarcerated persons to receive 5 days off a month for any month they did not have a major misconduct. And the amount of time they received off of their minimum and maximum sentence increased as the length of time they were incarcerated, all the way up to people who served 20 years or more, receiving 15 days off per month without a major misconduct. So that happens for a couple decades. And then the first big change we see is in 1978 with Proposal B, which was a ballot initiative that excluded people convicted of 80 specific offenses, primarily assaultive and property offenses, from receiving good time, requiring them to serve 100% of their minimum. As the legislative analyses predicted was going to happen, we saw very significant prison overcrowding, and only 4 years later in 82, the legislature passes disciplinary credits, which is similar to the idea of good time credits, but not a progressive growing amount, so 5 months or 5 days off per month. And then, we switch everybody to a system of disciplinary credits. And then it's in the early 90s that we see truth in sentencing start to be introduced in the state of Michigan.
Okay, I want to just hit pause for a minute. So we had good time for over 100 years in Michigan. What was happening in the 1970s that all of a sudden people wanted to get rid of it? And what was the rationale for doing that?
From what I've understood, the rationale has been similar to what our ideas of truth in sentencing were, that we needed to make sure that people were serving their full sentences, that the public didn't understand how long they were going to be incarcerated for, and that essentially we were being too soft on crime.
So this is really an idea that comes up in the quote unquote tough on crime era. Yeah.
Yes.
I want to go to Imani a second. I'd like to talk specifically about how does good time create incentives for behavior inside a prison?
So good time allows for people in prison to have a little bit more responsibility over the time that they're serving, which is really important because people need to have experience with being responsible over different aspects of their lives. And in prison, there isn't much that you have control over. But when you can have a little bit of control over your freedom, it restores a sense of hope. And so with good time, there's an initiative to not only have good behavior, but stay out of fights, stay in situations that are positive, try not to hang out with people that are in negative situations, to work, to try to use your time in productive ways. There's a lot of incentives that give people more of a sense of responsibility, of value, worth. They're able to use their time in a productive manner and be rewarded for the way that they're using their time. When you don't have good time in prison, it increases violence in the prison. People feel like they have nothing to lose. It doesn't matter anyway. What's the point? Those are the sort of attitudes that grow when people have no incentives for good behavior. And a lot of people will think or say, what's the point of giving people in prison an incentive to do anything? They're in prison. Well, when you're surrounded by chaos and violence and confusion, it's really important to have some sense of hope, restoration, value that you can hold on to. If you can at least keep track of the days that you've been doing well and make your reunification with your family come closer. If there's a potential for you to see your daughter's graduation or show up for your family in a way that you probably wouldn't have if you didn't have good time, get a job sooner, get married sooner. People have goals outside of the prison and they're able to strive and achieve for those things in a more meaningful way when they have positive incentives to strive toward while they're incarcerated.
So what I'm hearing is that good time creates incentives for people to invest in their own rehabilitation and to not get into conflict. And it's good for the prison environment, and that helps both people who are incarcerated, but also staff, right?
Yes, staff people see that there's more of a tense environment when there's no incentive for people to do better. Staff people every day are in this environment that is often depressing. There's a lot of conflict. There's fights that they have to break up. And they're in charge of dispersing tickets, giving out consequences. And that's their role as a staff person. And so if they have another role of a staff person in incentivizing people to have good behavior, rather than always coming down on people for bad behavior, that really changes the dynamic of the environment in the prison. It's no longer as much as an us against them mentality. We're working together to try to make a better environment for everyone, and we're working together to try to get you out of here sooner. Many staff that are invested in the well-being of the people that they are employed to protect want to see good time credits and an earned credit system established in the prison, because it really gives them some relief. It gives them more of a sense of peace while they're in the facility. They know that there's something that the people that they are in charge of protecting and serving, they know that there's something those people are striving towards. And so when that doesn't exist, it really creates a lot of dangerous situations in the prison for staff and prison officials to try to deal with when there's nothing to alleviate that tension.
That makes sense. So Annie, I hit pause in the middle of your recounting the history. So I want to take us back to 1978. There was a ballot initiative called Proposal B that eliminated good time for a certain subset of convictions. And you said just 4 years later, a new essentially good time system was instated by the legislature?
Yes, that is correct. In 1978, Proposal B was passed. And then in 1982, we see the implementation of disciplinary credits that were created specifically for those who were charged with Proposal B offenses.
Okay, and what happened from there?
So what happened from there is a few years later, everybody moves to the disciplinary credit system, because prior to that, there was part of the prison population was getting good time credits, part of the prison population was getting disciplinary credits, and I imagine it was rather messy. So, then moving forward, so that happened in '86. Then in the early '90s is when we start to see even more of these tough on crime era bills really popping up and getting a lot of traction. So truth in sentencing is passed in 1994, and it is tied to the implementation of the Michigan sentencing guidelines. So it's a little confusing because all of these initiatives were passed in '94, but they don't come to fruition until '98 and then really implemented in '99. So with the first kind of wave of truth in sentencing, there was a group of offenses, certain offenses similar to those in Proposal B, that were excluded from receiving disciplinary credits and had to serve 100% of their minimum sentence. And then 2 years later, everybody goes truth in sentencing. So as of December 2000, no one received any kind of, people sentenced after 2000 are not receiving good time credits or disciplinary credits. They have to serve 100% of their minimum sentence before they come under the parole eligibility.
Did the 1998 law have any relationship to the '94 crime bill that was passed at the federal level?
So the 1994 crime bill has received a lot of attention in the last 2 years. But one of the things that it did that we are still really receiving or kind of starting to finally understand how important this was, is there was an incentive that if your state implemented 85% minimum, you had to serve 85% of your minimum sentence for violent offenses, you were eligible for federal grant money to build prisons. However, as I said earlier, people in Michigan's prisons were already serving 88%. So we already met that threshold. However, we pushed it to 100%. And in just 2 years between 1996 and 1997, we received over $2 million just to build prisons.
Okay, so I've heard, and I'm going to go to Jessica with this question. I've heard from a number of people in Lansing that truth in sentencing is quote unquote constitutional. Is that true?
It is not true, and this is something that I have learned very recently, even though I've been under that same misperception. And I think that that goes to the strength of the, Imani kind of alluded to this, the strength of the marketing around truth in sentencing almost. As this, there was a huge PR push that this is what victims need. This is what the public needs to be safe, this truth in sentencing, and there's nothing that can be done about it. And I think that that has just become ingrained in the criminal justice community, that this is a constitutional change that happened, and there's nothing we can do about it short of, you know, amending our constitution. And that's just not accurate. There are things we can do about truth in sentencing from a statutory perspective. The question would be whether there's the political appetite to do that. And I will tell you that almost by and large, when I'm meeting with my clients, one of the first questions when I'm getting to know him or her is, hey, is good time going to come back? You know, I heard there was a bill. I heard there was a bill. Is it going to come back? And, you know, John might be able to speak to this more. I don't think there's a political will. And that's always my first answer to my clients is no, there might be a bill, but it's not going to go anywhere. As long as we have the current legislative makeup that we do. And that's why what Imani is doing is so important, and so just wonderful for all of our clients and loved ones that are incarcerated.
Yeah, so I'll go to Imani next. Then, Imani, can you tell the group how you got interested in truth in sentencing and what you've been doing to try and change the law?
Yeah. So how I got interested in truth in sentencing, I have a loved one who is incarcerated in Michigan. And while I was studying at the University of Washington over in Washington State, I got a message from my loved one saying, hey, there is a bill in the legislature to bring back good time. And this was in 2018, David LeGrand's House Bill 5666. And so that's what initially made me interested. I wanted to advocate for that bill. I saw that it had been drafted, introduced, assigned to committee, and I did everything that I could to let people know about this piece of legislation. The chair of the committee at the time was Clint Kesto. We were blowing up his phones. So that's what really made me get into the whole truth in sentencing. What is this? What can we do to change it? Because there was a difference of 7 years on my loved one's sentence as a result of this bill potentially getting passed. Instead of him getting out in 2027, he would have been out this year. And so I noticed that there were a lot of people who had those similar stories for their brothers, wives, sons. And so I knew that there was definitely a huge community of people that were ready to be organized around this issue. And so 2018 came and gone. The bill did not move out of committee. It never made it to a vote. And that's when I saw that I could not trust my legislature, the way that it was made up, to move legislation like this forward. And so in 2020 is when we as a community came together and drafted the Michigan Prisoner Rehabilitation Credit Act, which goes much further beyond House Bill 5666, which would have restored the good time system that we had prior to the truth in sentencing era and the disciplinary credit era. It also disperses credits to those who are working. It includes all individuals. There are no cutouts. It doesn't depend on the person's sentence date when they were sentenced. So it goes a lot further in making sure that more people have access to earning more time off that's dependent on their academic, behavioral, and professional achievement. So I became aware of a bill in the legislature. I saw that that was not going to work. And then I looked for other alternatives and worked with organizers to put together the People's Initiative that is MPRCA right now.
Cool. And what is the status of that effort?
So right now, the Michigan Prisoners Rehabilitation Credit Act has been collecting signatures and is in the midst of canvassing by mail. And so prior to the executive order that came out early March, we were able to collect over 100,000 signatures. People were sending in petitions. We were able to do a huge signature sweep on Big Tuesday where we collected a lot of signatures around the polls. And we were able to really work through families who had incarcerated loved ones that they were passionate about getting home. So then after the executive order, it made it very difficult for us to canvass in the traditional ways that we've been used to canvassing. And so we weren't allowed to congregate in large events and go to events and collect signatures. We couldn't stand on the street and collect signatures from strangers. There wasn't any relief that our Secretary of State gave to us when it came to alternatives like reducing the signature number requirement or even pushing back the deadline. So right now our deadline for collecting signatures is May 22nd. We have a couple 100,000 signatures, estimated about 200,000 signatures, and we're hoping that we can get another 150,000 signatures before our deadline. My prediction is that there are a lot of people that are at home still collecting signatures amongst their families that are sending in sheets. Right now, what we are doing in order to remedy the situation of not being able to go outside is that we are collecting signatures online. So we have an online petition, and everyone in Michigan who signs that online petition, and I'll drop the link into the chat box for you all, they are sent a paper petition in the mail. The paper petition looks like this. They fill out this petition and then they mail it back to us. And so we've been able to collect signatures that way. With the petition, people get a little flyer of how they can support the campaign from home. We have an online at-home advocacy guide that people can use to call into decision makers like the governor's office, like Director Heidi Washington, like MDOC, their facility, to check on their loved one. But we're really working on trying to collect as many signatures as we can. We haven't pulled out of the race. We still need to collect by May 22nd. So we're just asking folks to sign the online petition, request sheets. If you want more than one sheet, you can request sheets on our website, and really help us get this initiative on the ballot. So I also saw the question of the timeline. And so May 22nd is when our signatures would be submitted to the Secretary of State, and then the legislature would have 45 days to respond. They could respond by either accepting the initiative as is, and then it would go into law. They could accept it with recommendations for which we as a community would have to decide whether we accept or reject those recommendations. And then they could reject it. If they reject it, then we would see MPRCA on our November ballot, and the people of Michigan would be able to vote it into law.
Cool. I want to go next. So we're about 15 minutes from our Q&A period, and I want to go next to the COVID mitigation options. So Jessica, I'll go to you next. The governor's been issuing a lot of executive orders since the crisis started, using what I understand to be emergency powers. What does the governor have the authority to do with her emergency powers related to truth in sentencing?
The governor could do a lot. She has a lot of power in emergency situations, and there's a ton she could do here. And I know a lot of groups have been actively submitting suggestions to the governor about different actions she could take. She could suspend truth in sentencing. She could just suspend it. It's part of a statute. She could suspend it for the duration of this pandemic. She could do a more limited suspension and only suspend truth in sentencing for medically frail individuals, older individuals, vulnerable people as defined by the CDC, those with chronic conditions, pregnancy, etc. She could suspend, so the medically frail parole statute is an interesting beast, but there's perhaps not as effective as it could be, and some were hoping for. But she could do a lot with that to speed up that process, to get a lot more people paroled under an existing statute. She could instruct disciplinary credits to be applied. And I know the director of the Department of Corrections did issue in early April a director's office memorandum to have wardens go through and apply those discretionary disciplinary credits, which is usually only done on a yearly basis. So wardens are being instructed and encouraged to actually apply some of these disciplinary credits that maybe they hadn't in the past. So that's a lot. The governor can do a lot here. There also, I know, was a recommendation. There used to be this old statute called the Prison Overcrowding Emergency Powers Act, which would allow her to reduce sentences by up to minimum sentences by up to 90 days during the state of an emergency. So she could reinstitute something like that. So there's a lot here that she could do to mitigate COVID as it relates to truth in sentencing. There's a lot she could do outside of truth in sentencing too, which is a different discussion. But she certainly has power here to really amend this particular statute.
And you've mentioned in your earlier comments that you didn't think the political will to repeal truth in sentencing is there. Can you speak to the nature of the opposition to repeal that's out there? Particularly sort of given that there seems to be good policy grounds to have something like good time.
Sure. It's really complex. I've heard, I've been in this arena for many, many years, well over a decade. And I've heard kind of all opposition to reinstituting good time. One common argument you hear is, well, they should be behaving anyway, so why would we give them more for doing what they're supposed to be doing? The other thing that is interesting is this focus of prosecutors on victims. And they have prosecutors tend to lump victims into a whole as if they want the exact same thing every single time, which is the maximum sentence and keep them in prison as long as possible. And that's not necessarily the case. But that is one of the main arguments that you will hear against good time. The other interesting thing, I think, I don't know if anybody's on here who has a loved one who's a juvenile lifer, but there was a huge lawsuit about this. And juvenile lifers sentenced to life without parole for homicide committed under 18, they are being awarded their good time or disciplinary credits, again, subject to the dates, pre-1999. But when the legislature was writing the resentencing procedure for juvenile lifers, they explicitly said they don't get any good time. I mean, that's how entrenched this opposition to good time and disciplinary credits is. And that was a huge lawsuit, which the state fought. The state fought awarding these individuals their good time, and they lost. So, that could be an interesting place to look to kind of see how entrenched and strong this viewpoint is against awarding disciplinary credits or repealing truth in sentencing.
Anne, I want to go to you next. My experience with the issue is similar to Jessica's in that there's very strong ideological opposition to repeal, particularly from law enforcement groups and prosecutors. Do we know at all whether the public might favor a repeal?
Yes, actually, Safe and Just Michigan recently hired an independent research group to do a statewide survey for us, interviewing over 1,000 Michigan voters about a range of different criminal justice policies. And thankfully that survey ended like right before COVID became like a really big issue, because who knows what would have happened then. But so this is a pre-COVID. And there was a lot of different questions, but some of them were directly related to truth in sentencing. So when respondents were generally told that Michigan's truth in sentencing law required 100% of the minimum, and it was described just broadly like that. 50% responded that it was not a good law, and 45% responded that it sounded like a good law. But when we got more specific and asked if the respondent would support these reforms, so the first reform was to bring back the system of good time for good behavior and allow people to earn shorter sentences if they show rehabilitation through work and school achievement. 84% of respondents said that they would support such an initiative, and only 14% said that they would oppose. And then another related finding was about ending mandatory minimums and allowing judges to have discretion to consider individual circumstances. And again, we saw very high rates of support, 76% saying that they would support giving that discretion and getting rid of mandatory minimums.
So it's fair to say that in the general public, people believe that people who commit crimes change, or at least can change and be rehabilitated, and that they understand that doesn't necessarily happen in a linear way. You know, my experience with criminal justice issues and legislators is really, people don't like blanket policies. They like flexibility and policies that permit individualized decisions. And I think one of the weaknesses about the truth in sentencing policy is that it is a kind of across the board limit on what the Department of Corrections can do. And public opposition to a policy like that isn't surprising to me, because it does take away, for example, the department's ability to manage its population during a pandemic. And that's not just, you know, releases, it's where people can be held, how they can be treated. Like the system is not set up to deal with a situation like this. So we're about 8 minutes from 1 o'clock, and I want to give everyone on the panel an opportunity to make a closing statement before we go to Q&A. We've been getting a ton of questions, and I want to get through as many as we can between now and 1:30. But we'll start with Imani. You know, why should we repeal truth in sentencing, and what should people do to make that happen?
So we should be repealing truth in sentencing because, like I said earlier, there's no truth in the way that we sentence people. We need to add restoration to Michigan State's prisons. Right now, we have a prison system where people are just warehoused with no hope and no incentives, and they're just obsolete of any resources that would make them feel like they're valued in our society now and post-release, and they feel very far from their release. So it's important that we restore truth in sentencing in order to bring truth back into our sentencing system. And that is the narrative that we need to hold on to, hold tight to, and continue to say and speak as we advocate for this so that we can begin to change the public consciousness. And something that we can do right now is sign the Michigan Prisoner Rehabilitation Credit Act. It puts the power into the people's hands about what our sentencing structure should look like. It also is something that is currently in the process of potentially becoming new legislation. And so this is something that anyone who is a citizen in Michigan that has registered to vote or is willing to register to vote prior to the deadline can sign. Please click on those links and use the remote from home advocacy guide to call in decision makers and let them know how you feel about this legislation. But it is important for us as United Michiganders. I'm a Michigan native and I'm happy to be back home working on this. It's important for us to really make this huge change in our criminal justice system, and especially during this crisis, because right now we are failing our incarcerated citizens, and this change can really bring hope into a system that is currently devoid of such. So thank y'all for having me on this presentation, and I just appreciate our highlighting this really important issue.
Amy, I want to go to you next, and I'm wondering if you have a sense of what the impact would be on the prison population, on the cost of the system, if we repealed truth in sentencing. I believe we've got a $2 billion roughly corrections budget. There's 29 prisons, about 38,000 people in prison in Michigan. What would happen to those numbers if truth in sentencing was repealed?
If truth in sentencing was repealed, it would have a very significant impact on our system. Right, just reducing the length of time that people are incarcerated would, right, save the cost of incarcerating them, as well as giving them hope, giving them a chance to go back into society and, right, live the lives that they want to live. When the estimates were done about how much truth in sentencing was going to cost, they were estimating that implementing truth in sentencing was going to cost an additional $100 million a year, just in operating cost. I don't know if that has exactly come to fruition. I imagine it has, but we are talking about a very significant financial reduction if we were to repeal truth in sentencing. So what I wanted to close with, though, was that, right, not only is Michigan only one of 6 states that don't have some element of sentence reduction, and we're one of the most strict, and it's taken a global crisis for us to really be able to highlight this and talk about it. And I think that we need to keep the pressure on and keep paying attention to this issue, even when it is not a global pandemic, because this issue is still going to be here and it's still going to need to be addressed. Thank you.
Thanks, Annie. Final thoughts from Jessica. What would you like to leave the group with today?
I think, kind of going off what Ann said and what Imani said too, is that I think that this pandemic has really highlighted what we all know is a problem. We have too many people in Michigan's prisons and they are locked up for way too long. And I think, you know, there's so much talk about this right now in light of COVID-19, but that we can't lose sight of the problem in the first place, which is why we have so many people incarcerated. And so I think because I don't see the Michigan legislature enacting a statute that repeals good time anytime, or repeals truth in sentencing anytime soon, that Imani's petition drive is our best hope right now. And we should all sign that, but know that there are a lot of people out there who believe in the unfairness of this system, and we do what we can to challenge it.
Thank you. And thanks to the panel. We're going to go to questions now. I'm looking at 6 pages of questions and growing. So I don't know if we're going to be able to cover all of them. So just, I'm going to run through as much as I can. So first question I want to go to is just, there's a question about whether secure units at hospitals count as secure facilities. And this will be a general question for the panel, but how does MDOC provide medical care to people in cases that require hospitalization, particularly on an inpatient basis? Is that a good question for Jessica?
I'll start, and then if you all want to jump in, that would be great. So there are a couple secure units at prisons. I believe in Jackson and maybe Marquette has secure prison wards or wings of the hospital. That wouldn't be considered, like, you couldn't parole somebody to one of those secure hospital wings, but it is a place where people can get treatment. My understanding is if they need treatment at a hospital that is not near one of those secure wings, that they just go to the hospital, and they have usually 2 corrections officers with them that stay with them at the hospital. That's my understanding of how individuals are treated that do need to go to a hospital. I know that with COVID-19, it's a huge concern because our prisons are in a lot of rural areas who might not have the hospital capacity, let alone the equipment needed to help care for individuals that are sick in the prison. But my understanding is with the numbers we're seeing, there's no way all these individuals are being hospitalized that are testing positive for COVID-19. And of course, that's true in the world too. Not everybody is hospitalized, but it is a concern as this continues to spread, what the capacity of local hospitals is going to be for those serious cases, especially when you look at Lakeland, where over 60% of the population has tested positive for COVID, and they have a pretty high elderly population. Theoretically, a lot of those individuals might need to be hospitalized. So there is a lot of concern for the capacity of local prisons and the DOC to be able to treat individuals effectively.
And we got a couple questions about whether prisoners are being hospitalized. And just my understanding is not at outside hospitals. There is an MDOC run hospital in Jackson called Duane Waters. That's close to the other prisons in Jackson. That has 112 beds. So, not sufficient to hospitalize the number of people that are sick with COVID inside the system. Some of the early cases did go to Duane Waters, is my understanding.
And I would add that there are people hospitalized for other reasons at Duane Waters. So it's not as if all 112 of those beds could be used to treat exclusively people who are testing positive for COVID.
Right. Annie, Jessica mentioned Lakeland specifically. My understanding is that all of the prisoners at the Lakeland facility have now been tested. Can you talk a little bit about the demographics of that facility? And yeah, go ahead.
So Lakeland has one of our oldest prison populations, unfortunately. The average age is almost 50 years. And that is where if we look at the age breakdowns, over half of our population who's 70 and up is all incarcerated in Lakeland. So those are going to be the most vulnerable, and unfortunately at the location where we are seeing the highest rates of COVID-19.
Yeah, I think we've also seen the most deaths at Lakeland as well, which makes sense given the population. Yeah, that facility has an average age that's almost 10 years older than any other one. So it's really unfortunate that COVID got out there. Let's see. We got a question about commutations, and it's not our topic. We actually had a panel like this one on commutations the other week that is up on our website. You guys may want to check out. But there's questions about why are commutations so hard to get. So first, there's a couple issues. A commutation requires specific action by the governor, but it also requires a series of actions by the parole board, and a public hearing is required under current law for a commutation. All the procedures that are tied up in the commutation process, and that process applies to pardons and reprieves as well. The statutory deadlines are 9 months. And it often takes another 6 if a person is granted a commutation. So you're talking about a 15-month turnaround for commutations. It's just not something that can be done at scale. The current governor, to my knowledge, has not done any commutations. And most governors do not typically do commutations until the end of their terms. Governor Snyder commuted a couple dozen people in 2018. But it's unlikely to be used at scale. It's a cumbersome process. It could be streamlined using emergency powers, but we're not optimistic there's going to be a lot of commutations, unfortunately. And with 85% of the prison population not being eligible for parole, that means a large chunk of the prison population just isn't going to be considered for release under current law, unless there is an emergency executive order issued. So we got some questions. This is a good one. A little in the weeds, but We got a question about the Tanner rule, Jessica. Could you talk about the Tanner rule for indeterminate sentencing?
Sure. So the Tanner rule comes from a case, People versus Tanner, from the Michigan Supreme Court. And what it says is that a minimum sentence cannot be more than 2/3 of the maximum sentence. So let's say the offense for which you're convicted has a 5-year maximum sentence that's set by statute. Let's do an easier one. 6-year maximum statute. Well, I'm trying to do math here. Let's say it's a 6-year max, which is not really a thing, but we'll go with it. 6-year max set by statute for a particular offense. The minimum sentence, which again is set by the guidelines and the judge's discretion, cannot be more than 2/3 of that. So it wouldn't be able to be over 4 years. So, and that, that essentially, I think the intent there, or, is to give that parole board the discretion. There are problems that come with that discretion. The Council of State Governments did a lot of studying of Michigan's sentencing scheme a couple of years ago. And one of their findings that I thought was interesting is that the period of time controlled by the parole board when you're looking at a sentence is 300 to 400% longer than the minimum imposed by the court. So you have judges who are supposed to be imposing sentences based on a variety of factors. We do theoretically have several goals of sentencing in Michigan, including rehabilitation. But that period is substantially longer that the parole board has power over. So that's kind of what the Tanner rule does in its practical effects, is it can't be more than 2/3 of the max.
We've got a couple questions. I'm going to stick with you, Jessica. We got a couple questions about how concurrent, I think it's concurrent, but could you talk about how terms of years work with people who also have a life sentence?
Sure. So it would matter if it's a life without parole sentence or a parolable life sentence. That's one kind of, I don't know actually if it's a quirk of Michigan law, but what we have in Michigan is you go on Otis and you look up somebody and it says life. That could be parolable life, or it could be life without parole. For life without parole, unless you were juvenile at the time of the offense, your only remedy is through the governor's clemency powers. That's your only real hope, unless you're exonerated. With parolable life sentences, that's another process whereby the parole board has jurisdiction, and it's a very complex process, one that has similar lengthy time frames to what John was talking about regarding commutation. But if you have a concurrent sentence with a parolable life sentence, then the processes of the parolable life parole process are going to usually control, unless you have a really, really long concurrent term of years sentence, which we kind of call functional life, because there are those people who have very long indeterminate sentences. So I don't know if that answered the question. Please ask a follow-up if you want a little bit more information, but it kind of depends on the specific circumstances.
We've gotten several questions about plea bargaining too. And I think it is important. You mentioned that most sentences in Michigan are imposed through plea bargain. Could you repeat the number that you?
I believe it's between 95 and 98% of cases are resolved nationally through plea. And Michigan is no different than that. And I should also mention that I understand and people understand that not everybody is guilty who pleads guilty. That is an important qualification. Prosecutors have a lot of power and can push people into guilty pleas because it's so risky to go to trial. It can be so risky to go to trial. So I do understand certainly that people who plead guilty are not necessarily guilty.
Yeah, and you mentioned that very few people who plea bargain appeal sentences. Is there like is it typically a term of a plea bargain that a person's appeal rights are waived?
No, we don't do that in Michigan. That's a federal thing where a prosecutor might only offer you a particular plea bargain if you waive your right to appeal. That's not a thing in Michigan. So if you have loved ones who are going through the system, have them appeal, because there's also, especially in the guilty plea context, I do a lot of guilty plea appeals, and sometimes we dismiss the appeal. We don't go forward. There's nothing there. You got a good deal. There aren't issues, but have a lawyer look at your case. To see maybe there's a sentence reduction. Maybe you can get a change to your pre-sentence investigation report that would matter to the parole board. So always ask for lawyers. If you get arrested, ask for a lawyer. If you are convicted and sentenced, ask for a lawyer.
Absolutely. As a former criminal defense lawyer, I echo those recommendations. So I want to talk a little bit about, we've gotten some questions just procedurally about how do ballot initiatives work. And the 1978 one is kind of an interesting case. Annie, it's my understanding that the legislature would need 3/4 of each house to vote to modify that. Is that right?
Yes, that is correct. When a ballot initiative goes forward and is approved by the citizens of the state, in order to overturn that, you need 3/4 in both houses. So for example, with Proposal B that excluded all of those people who've committed those particular offenses, when that proposal was on the ballot, actually 2 million people voted for it. So almost 75% of the population who voted that year and chose to answer that question said that they thought that we should get rid of good time credits for those with those particular offenses. But thankfully there is that solution that if you can get 3/4 in both the House and the Senate, that initiative can be overturned.
So we've gotten several questions about what do other states do? And that's a complicated issue, but there's sort of two buckets of incentive systems that I'm familiar with. One is good time, which we talked about, where people get a reduction in their minimum sentence, or if it's a determinate system where a person just gets a flat sentence, a reduction in their out date. And that's basically judged by people in the facility. Did you get a ticket or not? There's a different system that I call earned credits, but they're called achievement credits or other things that, you get reductions in your minimum from accomplishments, like completing programming or a GED or other jobs in the system for good deeds. And many states have both of those things. Others have one or the other, but very few, in my understanding, have neither the way Michigan does. Annie, do you have a sense of how many states are like us? How much of an outlier we are?
We are one of 6 states, and I am actually putting something in the chat that has what every single state does as of 2018. But we are one of 6 states that have no earned time or good time credits. The other states are a little bit of a hodgepodge. We got Hawaii, Minnesota, Montana, South Dakota, Wisconsin, and us. So even the federal system allows up to 85% or requires 85% of the minimum sentence to be served.
And so we're an outlier, and states like Louisiana, Oklahoma, very tough on crime, pro-incarceration states don't have the system we have. They've got good time or earned credits or something similar.
Correct.
Interesting. We've got a number of questions for Imani about how people can get involved. Imani, I think you've put your website up and information for people in the chat, so I'll skip over those, but thanks everybody for your interest in the issue. I've got a question. It's quite interesting. It's where do crime survivor advocacy organizations stand on this issue? And I'll just speak for myself. There are two camps. There's a camp where certain crime survivor advocacy groups are pro-punishment and pro-long sentences, and so they are opposed to repeal. And there's other, mainly newer groups that are interested in criminal justice reform. And that divide goes across issues. It's not, you know, in my experience, dependent on the details of a proposal. You have ideological groups that want to see reform and ones that don't, and that are invested in punishment. So there's not uniform opinions. I think in the public discourse in Michigan, the sort of pro-reform crime survivor opinions has not been as well represented as the other group. But I am aware of groups that are organizing crime survivors in support of reform. And I think that's a really positive dynamic. Crime Survivors for Safety and Justice, you may be familiar with, is a national group that now has chapters in Michigan. If you're interested in getting involved, please look them up. That's an organization that we at Safe and Just Michigan partner with, and I think they're great. Let's see. I've got a few questions sort of on the daylight between Proposal B and the disciplinary credits that were implemented afterwards. And I'll go to you, Anne. What is your understanding sort of the legal requirements? You know, is Proposal B narrower than the subsequent law? Was the subsequent law enacted in conflict with Proposal B and just simply overcome by legislative majority? Or was it just something that didn't conflict with it at all?
So from my understanding, when disciplinary credits were implemented, since it was not, so Proposal B excluded Proposal B, people convicted of Proposal B offenses from good time credits. So by creating disciplinary credits, a separate system, I think we were able to move around the having to get the majority, but even when disciplinary credits were passed, it did receive 3/4 in both the House and the Senate.
We got some questions about the signature requirements. Got a couple questions, Imani, about, so, you know, are people able to check if they signed, or, you know, where should people go for that kind of information?
So the campaign website, mprca.info, is the best place to go to look for information about signature requirements, how to sign the petition, how to get a petition, to request a petition. Right now, we don't have any way, like I haven't got that question before, how do you know if you signed? But if you don't know if you sign again. I mean, if you don't remember, I have no problem with you signing twice. They'll just invalidate the second signature when they come across it. You can't legally sign twice. But if you really truly don't remember, just order another petition online and sign again. And then you can sign the online petition. I'll repaste those links if they've gotten lost in the chat for folks. But mprca.info is where you can find information about how to sign, where to sign, what the requirements are. You just need to be registered to vote in the state of Michigan. That's really the main requirement. And then I also saw another question about extending the deadline. We did ask to extend the deadline. We sent a formal letter. We asked with a coalition of other groups, and that just wasn't approved. And so we're still sticking with the May 22nd deadline, and we're still trying to collect the minimum requirement of 340,047 signatures.
Jessica mentioned on the chat that she thought there may have been a federal court case extending deadlines and maybe impacting signature requirements. I saw that too, and I think it was about candidates. I don't believe it applied to ballot measures. Is that your understanding as well?
Exactly. I did see that. And yes, they did reduce the signature requirement for candidates. They did not apply those same remedies to ballot measures.
Okay. Imani, I want to stick with you. So the initiative that you're advocating, that has elements of good time and earn credits, right? People can, you want to talk a little bit more about the details?
Yeah, so it has elements of good time, and it really restores the good time system that we had, a progressive credit earning system where you can earn time off 5 days to start, and then progressing up to 15 days each month for those serving longer sentences all the way up to and through the 20th year and on. And so that good time progressive system is restored. But in addition to that, we also allocate credits for honorably discharged military veterans. They allocate credits for people who were sentenced to serve time as an adult while they were under the age of 18. There's a special allocation for that. There's also a special allocation of credits for people who are striving for academic goals. So when people earn a bachelor's degree, associate's degree, or even a certificate, the credit earnings, they'd be able to earn additional credits for those achievements as well at the time that they receive their degree or complete that program. And then along with all of that, there's also earned credits for working prisoners. So we know that people in prison do have the opportunity to be employed either by the prison or by outside private vendor, and they often do not make a lot of money. I have a friend who trained seeing eye dogs, and he makes $40 a month. But in addition to that very small salary, what this bill would do is allow for folks to earn time off of their sentence. So for every year that they're consecutively working a position, then they'd be able to earn time each month. So there are a variety of different ways that people would be able to earn time off of their sentence, regardless of when they were sentenced. So it doesn't depend on the year that they were convicted, and regardless of the type of offense that they have. So it's inclusive of everyone, nonviolent, violent offenders. It really doesn't matter so long as you're striving to achieve, to grow and to develop in one of those areas that are outlined in the bill. So people can see the full wording of the bill on the back of the petition. So if you've ordered a petition sheet, it's on the back. And then you can also look on our website, nprca.info/documents, or just click the documents tab and you can see the full wording of the bill in PDF.
Cool, thanks. We got a couple questions about sort of impact of repeal, and one issue I just want to walk through for people is retroactivity. And this is an issue that we talk about a lot in legislative work, and what it means briefly is, does the legislation look back to everybody who it might apply to, or does it look forward and say from this day forward anyone entering prison has this right? And this is a very important issue, because if a bill is not retroactive, it doesn't help anybody who's convicted prior to the effective date. So you're not going to see impact right away. It'll build over time, but a bill has to be retroactive if you want to help anybody who's currently incarcerated reduce their sentence. So that's an important detail to pay attention for. If the bill was retroactive, then MDOC would have to go back through disciplinary records or achievement records to calculate for each individual what reduction would be from their sentence, and it would after that reduction whether the person is eligible for parole or not. So if the reduction gets someone to their minimum or past it, then they would go immediately to the parole board. If not, they would have to wait for their minimum sentence to be served. We got a couple questions about what appetite there is in the legislature to work on this issue. And I'll let you guys sort of weigh in, but here's my take. Legislators are curious about this issue. They don't understand from a policy standpoint, or many don't, why we would have made the changes we make and why we wouldn't have incentives for people to invest in their own rehabilitation. It's just that opposition, once mounted by powerful law enforcement groups and prosecutors, tends to scare people off from working on the issue. As Imani mentioned, there was a couple bills introduced last session by Representative LeGrand, who is Minority Vice Chair of the Judiciary Committee in the House, and Howerlack. Howerlack is term limited, but LeGrand is still there. I know he's interested in the issue. I think the barrier to progress is going to be sort of who controls the legislature, who controls the committee, and whether those people would be willing to bring a bill up for a hearing and a vote. So right now, the Republican Party controls both houses of the legislature, and it's really up to the Speaker, the Judiciary Committee chairs, the Senate Majority Leader, whether things come up for votes or not. And I think really the focus needs to be on persuading Republicans that a truth in sentencing repeal is a good idea. I've heard from staffers on both the Republican and Democrat side that they're talking about proposals. There's one I'm aware of for achievement credits, and I believe there's also a proposal to restore disciplinary credits, but no bills have been introduced yet. So talk to your legislators, tell them about the issue, tell them why it's important, because there's 110 people in the House and 38 in the Senate, and they all need to hear about this. Final question I'm just going to take here. Well, I'll take two more. The first one I can answer quickly. We got a couple questions about the survey that Ann mentioned. We're not going to put out the whole thing, but we do have something we can release related to the truth in sentencing questions. And we'll send it around, I think, to this group. And we may also put it out with a media advisory, but it's not something we've decided one way or another on yet, because I just didn't get to it. But we will make that information available. And one last question. Let's see. This question is sort of complicated, but it gets into the history. It's just, where did TIS originate? Was it initiated by legislators or the prosecutors or another group? So the 1978 ballot initiative was spearheaded by Brooks Patterson, who was the Oakland County prosecutor. And he's, those of you who are familiar with him know he was the county executive from 92 to last year. He was the Oakland County prosecutor from 73 to 92. He's a well-connected Republican, very well known for his tough on crime views. And I think for the ballot initiative, he's someone who was very involved, and there were others as well. Within the legislature, some of the key figures were Senator Van Regenmorter from West Michigan. He was involved in getting the Crime Victims' Rights Act put into the state constitution. That was in, I believe, 88. And he was also, I believe, a committee chair during the push in the 90s to bring the 100% of a minimum truth in sentencing policy through, along with the sentencing guidelines. And, there are folks who were involved in those efforts that worked for Attorney General Schuette when he was the AG from 2011 to the end of 18. And, there's a lot of people who have been involved over time. My experience is that PAM, that's the Prosecuting Attorneys Association of Michigan, is very committed to truth in sentencing. It's something that I've heard past presidents talk about in detail, and it's sometimes spoken of as their number one legislative priority is preserving truth in sentencing. So persuading prosecutors to change policy is also important because they are extremely influential with legislators. And we're at 1:30, so I'm going to wrap it up. And thanks everybody for joining us. Thanks to the panelists for making time to talk about this. And please, talk to your legislators about these issues. Thanks.
Safe and Just Michigan thanks you for participating in today's event. We'll be hosting several upcoming webinars, including one on violence next week on Tuesday. On the screen, we've just included several ways that you can keep in contact with Safe and Just Michigan. Thanks again for participating in today's panel.